Thank you very much to the organizers for counting on me for these very interesting seminars. I'm going to talk about three simple ideas. I love number 3. I don't know why. I think it encloses mystery or like magic. I don't know. But those 3 things are, I'm going to talk about constitutional principles in Spain regarding church and state relationship. Second, how we implemented these principles regarding to religious minorities. And then the third thing is, as a conclusion, 2 cases of good practices that we learned from our mistakes. Let's see. Our constitution says, like all constitutions in European Union, recognizes religious freedom as a fundamental right of individuals and groups. But someone said, where do we draw the line? You know, it's a question of limits. All human rights have limits. Our constitution offers a simple concept. The limit for religious freedom is public order. But then we have the law of religious freedom 1 year later of the Constitution, 1980. It says it draws another 2 lines, enshrines 2 limits. First limit, respect of other human rights of other people. Like the concept, another human right is the right of education. Education, you have to see the teacher's face. There's no possible education without seeing the face of the teacher. Anyhow, respect of fundamental rights of others. And second, public order. Public order is a legal concept with 3, another time, again, number 3 dimensions. It says public security is like a triangle with these 3 lines. Public security, public health, public morality. Okay, they have to be implemented, but okay, maybe later. And then in the Constitution also says that that all relations between state and denominations have to be developed in a metaphorical area divided by 2 coordinates, have to respect 2 principles. First, the principle of non-confessional state, secularism, and the other principle is cooperation. Spain is different in that way. Cooperation. Let's see in very briefly these 2 concepts. Principle of non-confessional state. It comes from a constitutional statement. No religion shall have a state character. And this coordinate is sustained in 2 pillars, separation and neutrality. Separation between churches and state. That means churches and state are independent and autonomous entities. It means that neither state nor churches can intervene in the own sphere of the other. What does it mean? State cannot interfere in the realm of religious groups. For example, it cannot say Catholic Church how to organize, or it cannot even say if women should be priests or not. This is a question, internal question of the confession. But churches cannot intervene in the sphere of the state. What does it mean? Churches cannot assume roles of the state. But what is that? It means that churches have dogmas, moral, but they cannot pretend that their morals or their dogmas become automatically law. This is a competence of Parliament. They can, of course, speak, but in Spain, as an example, there are not any more seats reserved to bishops, as it used to be in Franco's dictatorships. By the way, there are in the UK, there are bishops in the House of Lords still. But we should not mistake between this separation principle and freedom of expressions. Those 2 fundamental rights sometimes crashes, because religion, of course, any denomination can criticize the government or its laws, of course. This is not interfere in the realm of the state. This is just freedom of speech. It has its limits also. But, okay, then this is separation, neutrality. What does neutrality of the state before the religion means? Neutrality, like Aristide Briand, what he demanded. Neutrality means that state is not competent in religious affairs. State cannot practice any faith, nor value, nor assess the legitimacy of religious beliefs. This is only a competence of individuals and groups, which are holders, the only holders of the human right of religious freedom. So, state cannot determine which group is a real religion or a fake one, which group is a sect, because a sect is not a legal concept, it's a sociological concept. A secular state cannot define by principle which is religion, which is not. So the state cannot be neither confessional nor atheist, should be neutral. We say laico. In Spain we difference between laico, like is secular, and laicista. Well, laicista it's more. The difference is state laicista, I think like sometimes France, is a state that has prejudice against religious group, treating them worse than to other religions. Okay, why a kid can go to school with a T-shirt of Madonna or of Mao Zedong and not with a cross? It's treating worse one group than other, okay? The other coordinate, that's secularism or no confessional, and the other is cooperation. In the Constitution, it gives two clear orders to public authorities, to public powers. First, take into account religious beliefs of the Spanish people, the Spanish citizens of Spanish population, and second, as a consequence, maintain cooperation relationship with, it says so, Catholic Church and other denomination. It doesn't mention anymore about cooperation, but so far the main instrument of cooperation have been signing cooperation agreements with religions that have obtained one classification, have been classified as deeply rooted or firmly rooted denomination. So, in conclusion, all relations between church and state should respect this principle, should be developed in a metaphorical area formed by those two coordinates. Then, second, let's see how we have implemented in one these principles in one specific field, recognition of religious minorities. Because in Spain we have a register of religious entities under the Ministry of Justice. To be entitled to religious freedom, a group doesn't need to be registered. It's not necessary. They are entitled to religious freedom. But if they do, if they enroll the register, they have some extra rights we'll tell about. But they can be registered if they fulfill these requirements. First, they have to present notice of their foundation and their establishment in Spain. Second, its entity name. It has to be appropriate to distinguish from other religions. Entity name and address. Third, internal norms of the confession and their representative bodies. And then it says declaration of religious purposes. That's the... Okay, but why they register? Because, as I said, there are some specific rights. Then the case of two examples of good practices regarding the application of some religious minorities who wanted to be enrolled in the register. Okay? I'm going to explain two examples, two mistakes that ended in two cases of good practice. First, thanks to the collaboration of Constitutional Court, of course. First, the temptation, the theological temptation of the state. Okay, sometimes it was a former wrong attitude. Sometimes the state fell into the temptation of assuming the role of maximum cleric, deciding whether a group is religious or not. Even being neutral, he fell into that temptation. And it used to do so, having in its unconscious mind the paradigm of traditional religions, monotheist, traditional, basically Catholic Church. For example, one example of this temptation, when Church of Unification or Scientology first demanded to be enrolled in the register. The register of the Minister of Justice and also some judges answer, your purposes are not religious, they are philosophical, so you are a philosophical group, not a religious group. Okay? It came the correction from the Constitutional Court, and it said two things. State cannot make a material control, but a formal control. What is, a secular state cannot make a material control. In other words, control the legitimacy of beliefs. If it's this, you are a religion, real religion, you are not. You are a fake, you are a sect, you know. Because this attitude is against its nature, is against neutrality. The state cannot value nor assess religious dogma. This is a competence of citizens and groups, but not of the state. The holder of religious freedom is not the state, are individuals and groups. Besides, according to the official interpretation of the Human Rights Committee, the term religion should be broadly interpreted. It said, not limited to traditional religions or similar, so religious freedom protects theistic, non-theistic, and even atheistic beliefs, new established religions, and also those followed by a minority of people. The state role is the formal control. In other words, control if a group fulfill the requirements, as the legal requirements we have described before. And when it comes to that requirement, religious purposes, the state should make an act of faith, because he should presume that the group believes in what they say. Why suspecting? If you have proofs, solid proofs, that this group searches criminal goals, but the group, not the individual, then you have reason to deny register or to deny his existence. You cannot admit the mafia because the group searches criminal goals. Second temptation, another wrong attitude, temptation of prejudice. Not the state, the society is full of prejudice, is the cancer of knowledge, prejudice. But sometimes the state is a victim and echoes prejudice and accept stereotypes, the stereotypes existing in society. For example, this group kidnaps its followers, abducts its followers, and then goes in this direction. Correction of the Constitutional Court. Charges are to be proved before the court. Evidence, not rumors, are needed to condemn. And then, you cannot criminalize an institution for crimes of individuals. There are bishops who have committed child abuse, but this is not the goal of Catholic Church. You cannot criminalize Catholic Church because of that. That's another example. Scientology went through a long criminal trial in our country, accused of many crimes, even Franco's death, you know, many, many crimes, but at the end it was acquitted of all of them. So, if the state, the register, suspects that a group uses methods or seeks for illegal goals, okay, it should do something. Stop the process of registration, send the case to the judge, and only if that group is condemned guilty, the refusal to register is acceptable. So I finished saying why is so important, I said before, being registered in Spain. Because first, well, in France, as you said, law of 1905 says no religion is recognized. In Spain, if you are registered, you have the legal recognition from the state of your religious character. And then another extra right, if you are registered, you can opt to be classified as deeply rooted confession, deeply rooted religion, and if you are this classification, you can opt to sign a cooperation agreement with the state. So it means, according to the Spanish law, we should distinguish among 4 types of denomination from a legal perspective. Denomination non-registered, they are groups, they are religious groups. Religious registered, enrolled in the register of religious entities. Religious registered, but that have obtained also declaration of deeply rooted or deeply or firmly rooted in Spain. And the 4th one, religious denomination with cooperation agreements, which have signed cooperation agreement with the state. So far, there are 4 religions that have signed this cooperation agreement. One of them, the first Catholic Church in 1979, and this agreement is also an international treaty, so it's a strong law. And the other 3 denominations which have already obtained the declaration of deeply rooted are Jews, Muslims, and Protestants. Well, thank you very much.